My name is Sonu Bedi. I'm an associate professor in the government department. I'm also the convener for our legal studies faculty, which is a working group of faculty members who sort of have an interest in the law. And first, let me say, if you have cell phones, to turn them off. In fact, recently in class, my cell phone did go off, and so I had a cool ringtone. But you know, I didn't want to inflict that on anyone. So if you could turn off your cell phones. Oh, you can't hear? Okay, if you could turn off your cell phones, that would be great. Let me say a few thanks in order. I particularly want to thank Sadhna Hall and Joanne Needham at the Rockefeller Center here. Without their help, we would not be able to have this kind of lecture. They really make it very easy. And also the Dartmouth Lawyers Association, who provide financial support for our endowed lecture series. So today it's really my great honor to introduce our annual William H. Timbers lecture. So just to give you a little bit background on this lectureship, William Timbers was a class of 1937. He was a lawyer at Skadden Arps. And also a practicing judge. He sat on the Second Circuit Court of Appeals. And the funds for this lecture are devoted to visiting speakers who sort of engage the issue of law and justice. And I can't really imagine a better speaker than Professor Robin West. Professor West is the Frederick J. Haas Professor of Law and Philosophy at Georgetown Law School, and before there, she was at the University of Maryland Law School. And if you go to her webpage, you'll actually see, you can't really get someone that's more prolific. It's really very envious. It's like there are pages to go through of all her books and articles. And I will say that actually in the seminar on justice that I teach here at Dartmouth, we often read one of her older articles from 1988, Jurisprudence and Gender. That's not even on the list of published articles on her webpage because it only starts in the year 2000. But one thing that's interesting about her work, and her work really covers issues of gender, feminist legal theory, constitutional law and theory, jurisprudence, legal philosophy, law and literature, is that really every single work that she does is insightful and nuanced. It's really not sort of some repackaging of an idea over and over again. And so I will just say that Jurisprudence and Gender article probably generates the best discussion in my justice seminar, which is really sort of an argument about the dark side of the law, as I like to characterize it. And so she's not going to be talking about that today. She's going to be talking about civil rights. But with that being said, her talk today is going to be titled Toward a Jurisprudence of the Civil Rights Act. So if we can give a warm welcome to Professor Robin West.
Okay, thank you very much for the invitation to share some work with you today, and thank you for coming and for your interest in the topic. The question I want to raise is this: what is the nature of the rights, jurisprudentially, that the 1964 Civil Rights Act legally prescribed? More generally, what is a civil right? Today, lawyers tend to think of civil rights, and particularly those that originated in the 1964 Act, as anti-discrimination rights. Our civil rights on this understanding are our rights not to be discriminated against by employers, schools, landlords, property vendors, hoteliers, restaurant owners, and providers of public transportation, no less than by states and state actors, on the basis of race, gender, ethnicity, age, sexuality, or disability. Contemporary civil rights scholarship overwhelmingly reflects the same conception. Our civil rights are quasi-constitutional rights to be free of discrimination in the private as well as the public world. But this conventional lawyerly understanding, basically that civil rights are anti-discrimination rights, is clearly inadequate, certainly with respect to civil rights generally, but also, and more tellingly, even with respect to the rights created and then protected by the 1964 Act itself. So first, on the general point, some of the civil rights sought or held across our history have not been anti-discrimination rights of any sort at all. Labor rights, welfare rights, free speech rights, and the constitutional rights of criminal defendants have all at various times been championed as civil rights, and these rights are neither logically nor jurisprudentially tied to any conception of anti-discrimination. But furthermore, even the civil rights which are defined and then protected against discrimination by the 1964 Civil Rights Act, as well as by various civil rights acts both before and subsequent to that one, are not, in circular fashion, simply our rights not to be discriminated against on the basis of impermissible characteristics. Rather, the civil rights of which we cannot be discriminatorily deprived are, after all, rights to something: a right to vote, a right to physical security, a right to enter contracts, a right to own, buy, or sell property, or a right to legal recourse in the aftermath of a wrong committed against us, a right to write a will, a right to be considered for or to hold down a job and to be paid fairly for our labor, or the right to the use of a restaurant or a hotel or a city bus, or to a public education, or to marry whom we love. And these are just some of the public goods that have been recognized at various times as civil rights, of which we cannot be deprived by discriminatory action. So even if just that much is right, then the civil right that's protected by all of our civil rights acts, including the 1964 Act, is considerably more complex than the conventionally legalistic and formalistic equation of civil rights with anti-discrimination rights suggests. Minimally, the civil right that's recognized or protected by the various civil rights acts is almost invariably multi-layered, or to put it differently, it's a right to a right. It is a right to not be discriminatorily deprived of some underlying right. Only the first right in the phrase "a right to a right" is the anti-discrimination right. The second right is the underlying civil right of which we cannot be discriminatorily deprived, and it is both itself complex and it's highly variable. It might be a common law right, such as a right to enter contracts or to sell property. It might be a statutory right, such as the right to vote. It might be simply a right to a social or public good, such as employment or educational opportunities, or the protection of a trustworthy police force against private violence. And while we have generated a library of writing and jurisprudence and judicial opinions on the nature of the first right in that phrase, the right not to be deprived of various rights on the basis of race, sex, and so forth, we've devoted much less attention to the second right, the nature of the underlying right of which we cannot be deprived. So then the question, what is the jurisprudential nature of that right? What is a civil right, both with respect to the rights protected against discrimination by the Civil Rights Act of 1964, and more broadly, again, what is a civil right? So oddly, I believe, and in spite of their importance in our contemporary life, we are woefully short on a jurisprudential understanding of civil rights, both with respect to the Civil Rights Act of 1964, whose 50th anniversary we celebrate this year, and more broadly. We have recently seen an explosion of scholarship on the histories of both the civil rights movement of the 50s through the 70s and of the civil rights acts they produced, but there has not been, either during or following the various legislative moments that have ushered in civil rights laws, a body of scholarship that's engaged in reflective debate over the jurisprudential nature of the civil rights that those acts sought to win and then to protect. We simply do not have a scholarly jurisprudential canon that seeks to encompass not only the nature of the anti-discrimination norm that our various civil rights acts codify, but also the nature of the substantive underlying rights that all those rights against discrimination protect. Legal scholars have, for better or worse, focused on judge-made law, and particularly judge-made constitutional law, when they're engaged in the work of discerning the overarching principles of rights, and nowhere is this more clear than in the areas of law and life touched by the Civil Rights Acts themselves. I will return to that problem in a few minutes. Here, I just want to note by way of introduction that for whatever reason, our scholarship on civil rights has shortchanged the complexities of both the Civil Rights Acts and the civil rights movements and their product, civil rights, more broadly construed. We have focused our scholarship almost entirely on the rights to non-discrimination that the Civil Rights Acts created, but we've neglected the need to understand the nature of the underlying rights of access to the social goods, systems of law, or institutions, contractual freedom and powers, property ownership, education, employment opportunities, public accommodation, family life, and so on, that those non-discrimination rights were designed to protect. So this is a neglect that matters for at least two reasons beyond the obvious problem that the neglect itself fosters confusion, with disputants and debaters often talking at cross purposes. But there are two deeper worries. First, the lack of a jurisprudence of the Civil Rights Acts that centers the underlying civil rights and not just the anti-discrimination norm likely reflects as well as contributes to a lack of appreciation of the civil society and of the laws that facilitate it, that civil rights, historically and today, both depend upon and produce. But second, the lack of jurisprudential study of the underlying civil rights protected by our various civil rights acts throughout our history has quite possibly skewed, and I think has truncated, our inherited civil rights traditions, as well as the possibilities for their creative regeneration. So civil rights, as well as the civic and participatory life they facilitate, can be threatened not only by discriminatory private practices of the sort prohibited by the Civil Rights Acts, but by much else as well. Our natural rights to participate in family life, for example, can be threatened not only by discriminatory state marriage law that grants rights to form families or marriages to some people but not to others, but it can also be threatened by private or intimate violence within those marriages that goes unaddressed by states, by a punitive criminal justice system that over-incarcerates marriageable men for trivial or victimless offenses, by a lack of community support for our caregiving obligations. Our civil rights to a healthy and physically secure life can be threatened not only by sexually discriminatory medical treatment or racially discriminatory policing, but also by a lack of affordable health care, a lack of trustworthy police protection against private or neighborhood violence, and an unhealthy and polluted planet. Our rights to decent employment opportunities can be denied us not only by intentional discrimination or neutral rules with discriminatory impacts, but also by a lack of skills and skills training, jobs outsourcing, plant relocations, capital strikes, and high unemployment. Rights to education are frustrated by a lack of preschool readiness and lack of community support for parents of newborns, infants, and toddlers, as much as by racially discriminatory admissions or school districting policies. The scholarly focus of the last 50 years on the nature of discrimination and its unlawfulness, rather than on the full array of obstacles that stand as barriers to the enjoyment of civil rights, without insisting on the point that discrimination is but one such obstacle among others, has shrunk our understanding and appreciation of our own civil rights tradition, as well as its regenerative potential. So, the talk and the essay from which it's drawn seek to begin such a conversation. In the first part, I'll introduce or reintroduce, and then I'll endorse, a definition of civil rights put forward by Thomas Paine over 200 years ago, well before the idea of non-discrimination had taken hold in his famous and indeed iconic pamphlet, The Rights of Man. In part two, I'm going to elaborate a bit on my constructed Painean conception of civil rights by contrasting civil rights so understood with what I believe is an emerging and new paradigm of constitutional rights, which I have called elsewhere and earlier today, exit rights. And then the third part, I want to revisit the Trayvon Martin killing and its aftermath in light of some of these distinctions. So first, on Tom Paine's civil rights. So, according to this influential, much-quoted definition provided in Thomas Paine's canonical late 18th century essay, Rights of Man, civil rights, he said, are those natural rights that are owed by a government to the people, all of them, by virtue of their membership in civil society. Civil rights, Paine held, are a subspecies of natural rights, a claim that was repeated and then embraced, indeed insisted upon, by the proponents of the 1866 Civil Rights Act, 3/4 of a century after Paine wrote. Natural rights, in turn, according to Paine, are rights we enjoy solely by virtue of our humanity. Their content is derived from our nature, not from any rule of recognition, and we hold them regardless of the accident of the geographical details of our birth. We hold them against our own sovereign, whether or not the sovereign recognizes them, and we would hold them likewise against any sovereign. And we all hold them, Paine thought, slaves and American Indians no less than free men. Civil rights are not, however, coterminous with the natural rights which man possesses by virtue of his humanity, at least according to Paine. Rather, civil rights are a subset of all natural rights, with two characteristics differentiating them from the larger class of natural rights. First, civil rights, unlike other natural rights, are rights that attach by virtue of one's membership in society, rather than solely by virtue of one's humanity. But second, although civil rights originate as natural rights, Paine explained, unlike some other natural rights, such as rights to the mind and conscience, or rights to behavior that doesn't harm others, civil rights are those rights that cannot be perfected by individuals standing alone or outside civil society and law. We need the affirmative assistance of positive law. So defined, civil rights included for Paine, quintessentially, those rights pertaining to the protection of the physical security of the individual. The security of and the protection of the physical body are examples, then, for Paine, of foundational civil rights that are only imperfectly at best enforceable through self-help. We trade in our natural rights to self-protection and security, so to speak, for the civil right of the protection of our physical security by the state. So how does Paine's account of civil rights, again penned long before the Civil Rights Acts of either of the 2 centuries following and before the idea of anti-discrimination as an actionable wrong had occurred to anybody, how do Paine's accounts of civil rights as natural rights that appertain to man and right of his being a member of society, that's a quote, but, quote, to which his individual power is not in all cases competent, stand up as a jurisprudential account of civil rights, both those passed into law 50 years ago and in various statutory provisions both before and since? Better, I think, than our current lawyerly equation of civil rights with anti-discrimination rights. At least echoes of Paine's definition can be heard not only in the Civil Rights Act of 1964, but in virtually all of the various civil rights acts and movements of both the 19th and the 20th centuries. So here's a real quick historical survey. So, according to the framers and advocates of the seminal Civil Rights Act of 1866, civil rights include rights to enter and enforce contracts, to buy, hold, rent, and sell property, to sue, to be parties, or give evidence in judicial proceedings, to enjoy the protection of the state and its laws pertaining to the security of persons and property, all of which fit readily Paine's description of civil rights as that subset of natural rights that should attach by virtue of membership in society and that require legal definition and legal institutions to perfect. These civil rights, as they were then called, clearly required positive law for their perfection. The power to make and enforce contracts requires contract law. The enjoyment of property obviously requires property law. Rights to sue and give evidence require the law of procedure. Rights pertaining to the security of persons and property require the assistance of the criminal law, and so forth. The Civil Rights Act of 1871, one of the enforcement acts passed in the wake of the Reconstruction Amendments and popularly known as the Ku Klux Klan Act, implicitly added personal security from various private conspiracies to commit, among other wrongs, violence against freed slaves to the list of civil rights to be enforced by the federal government rather than state militias. Here, too, the extension fits Paine's understanding. The natural right to be protected against private violence had been granted to some people by the criminal laws that prohibited and then enforced by state authorities, but that protection had not been extended to the protection of the freed slaves against private conspiracies contemplating violence, such as lynchings, against them. Thus, the need for the Ku Klux Klan Act. For the authors of the constitutionally doomed Civil Rights Act of 1875, civil rights also included the right to use public accommodations, such as hotels and restaurants, and to employ public transportation, and to enjoy and participate in public amusements, such as theaters. Here as well, these rights to participate sociably in these public spaces of civil society, which attach by virtue of membership in that society, require law for their creation and enjoyment, and the Act of 1875 created a non-discrimination right to enjoy those participatory rights. That act as well, then, which was later ruled unconstitutional by the Supreme Court, fits Paine's definition. That's the 19th century. In the 20th century, the phrase civil rights takes on new meanings, but nevertheless holds close to the jurisprudential core of Paine's definition. Thus, the idea of civil rights in the post-Lochner era, this is around the 1920s and 30s, included foundationally labor rights, including not only rights to be free of peonage and involuntary servitude derived directly from the 13th Amendment, but also eventually the right to join a union, the right to strike, as well as rights to minimum wages and work conditions. Participation in the labor economy as a free and equal citizen, some new legal historians have shown, was viewed as key to a shared civic life, at least by the New Deal-inspired Justice Department-housed lawyers of the 1940s civil rights section, and who were responsible for giving content and meaning to the civil rights that they were charged to enforce. In Paine's language, these labor rights, then, are natural rights that attach by virtue of our humanity, but they're civil rights by virtue of our membership in society. So in a now much-studied history during the middle and the second half of the 20th century, the content of civil rights shifts away from labor rights per se to the rights of minorities to enjoy employment and educational opportunities free of discrimination. And it was during that time period that the lawyerly identification of civil rights with anti-discrimination rights apparently took hold, at least, again, according to historians of the era. Here as well, though, the underlying civil rights to employment and education opportunities, I think, can be fairly described as natural rights owed to individuals by virtue of their membership in civil society, and which cannot be enforced by individuals standing alone. In the last few decades, by dint of at least occasional, if not common usage, the phrase civil rights is sometimes understood, particularly outside of legal circles, as including various statutorily or constitutionally created rights that facilitate family life, such as the right to marry without regard to sexual orientation, the right to family or medical leave from work necessitated by the birth of a child or the illness of a family member, and a right to be free of intimate violence as protected by the Violence Against Women Act, rights derived from various sources to a high quality as well as integrated public education, as imperfectly echoed in statutes like No Child Left Behind, an idea, as well as a right to health care, the existence of which is strongly suggested by the Affordable Care Act, of course. Here, too, the underlying natural rights to family, parentage, marriage, safe intimacy, quality education, and access to health care can be described as owed to all of us by virtue of societal membership. And here as well, they're rights that cannot be enforced by any individual without the aid of considerable positive law. So they all look like Paine-styled, Painean civil rights. Thus, all of these early, mid, and late 20th and early 21st century civil rights laws, or in some cases unfinished civil rights campaigns, protect civil rights that loosely fit Paine's definition. Most, although not all, protect those civil rights against some form of race, sex, disability, age, or sexuality discrimination. What they all do, though, is protect these various civil rights against some sort of unjust social ill, either discrimination or poverty or joblessness or lack of insurance or private violence, unequal allocations of unpaid intimate labor, with its consequent disparate impacts in workplaces, all of which in turn hamper enjoyment of underlying civil rights. In all of them, the underlying civil right protected against these pernicious forces is a right to engage or participate in some aspect of civil society: employment, education, marriage, family life, access to health care, physical security, and the mobility that goes with it, contract exchanges, ownership of property, all of which is in turn facilitated through legal processes. And in all of them, again, echoing Paine, the underlying right that is being protected or extended or guaranteed is not simply a natural right, although it is that. It's also a right, meaning it's a right that should attach by virtue of humanity. But it's also distinctively a civil right, meaning it attaches or should attach by virtue of membership in society. So let me extract 4 definitional principles. I think I shrunk it to 3, but anyway, 3 or 4 definitional principles of the nature of a civil right from this application of Paine's definition of civil rights to the examples I just surveyed of the rights protected by the various civil rights acts. First, a civil right is a natural right, meaning it is a right that attaches by virtue of one's humanity. In contemporary terms, since we don't typically talk that way anymore about natural rights, we might restate the same point in this way, drawing on our March of Sen and Martha Nussbaum's universalist account of human well-being. Civil rights, like all natural rights, protect or nurture our fundamental human capabilities, the capabilities we have by virtue of being human, for long and healthy lives, for cultural and intellectual engagement, for play, for interacting with the natural environment, and so on, enjoyment of which are the preconditions universally for living a good life. Some of those human capabilities, of course, are nurtured by familial direction during childhood, and then furthered and directed by dint of individual effort. They require nothing more than benign neglect from the state for their flowering. Some of them are also, though, furthered by social institutions and the laws that structure them, and some of them are indeed fully dependent on those social institutions and laws. Thus, our capability for health and longevity is furthered not only by a sensible diet and plenty of exercise growing up in a healthy household, but also by access to health care throughout life. Our capability for mobility and physical freedom is furthered not only by strong limbs developed by natural and healthy maturation, but also by protection against violence and the policing that provides it. Our capability for intimacy, not only by the flowering of private lives that seek it, the emotional health that sustains it, but also by the promise of family life that will be protected by sound policing against external threat and internal abuse. Our capability for sociability, not only by a natural capacity for language, but also by access to legally structured public accommodations and public spaces. Our capability for stimulating mental life in adulthood, not only by being left alone to discover or not Pythagorean theorems on our own, but also by high-quality public education with sound curriculum and pedagogy, and the law that structures all of that. The civil right in all of these cases is the right to access those institutions and to the enjoyment of the laws that structure those institutions, which protect and nurture natural capabilities. The various civil rights acts, in turn, provide that those rights cannot be discriminatorily denied. The same relation holds for our newer civil rights. The Affordable Care Act directly protects, through this complex regime of rights and responsibilities, the individual capability to live a healthful life, while No Child Left Behind and the Individuals with Disabilities Education Act protect, again through rights, the fundamental capabilities we all share for exploring the world and enjoying a lively mental and cultural life. The Family and Medical Leave Act encourage our capabilities for both work and for family, and state gun safety laws and the Violence Against Women Act aim to do the same for our capabilities for intimacy, mobility, physical security, safe sociability, and freedom from fear. All of these are human capabilities that are essential to a good life on Nussbaum and Sinn's account. And all of these capabilities are protected through the social and civil life that law and society both aim to structure. Our civil rights, I want to argue, can be understood as the rights to enjoy the fruits of all of that law. And our civil rights acts, again, are laws that guarantee that those civil rights will not be discriminatorily denied. Okay, my second principle also tracks Paine. Civil rights are natural rights that attach not only by virtue of man's humanity, but also by virtue of his membership in society, as Paine put it. Briefly, civil rights center our rights to participate in community rather than our rights to be free of community. So Professor Rebecca Zeitlow is entirely right for just this reason when she refers to the anti-discrimination rights created by the 1964 Civil Rights Act as rights of belonging. Anti-discrimination rights that attach by virtue of one's membership in society, as Paine put the point, are rights of belonging in Zeitlow's near-biblical usage. The point can, however, be broadened beyond her intended meaning. First, the underlying civil rights protected against discrimination by both the 1964 Civil Rights Act as well as the civil rights acts that came after it are also themselves rights of belonging. They are all rights to belong to or participate in various communities, communities of employers and employees, of landlords and tenants, of buyers and sellers, of students, teachers, and administrators, of neighbors and officials and polling places. The acts protect the civil rights of workers and buyers and sellers and tenants and voters and citizens and students, teachers, producers, and consumers to participate in these various communal workplaces, neighborhoods, markets, schools, city halls, courthouses, and voting sites. And they do it through accessing the legal forms and the rules and the entitlements that structure those communal locales. They aim, in other words, to bring us together contractually, educationally, civilly, and so on. The aim of those laws in toto, then, is a participatory community by virtue not only of the anti-discrimination norm, but also by virtue of the nature of the underlying rights. All of those rights seek to build trust between classes of strangers, once indifferent or implacably hostile, and all do so toward the end of strengthening a community's civic bonds. Other rights won or fought for as civil rights in our history can also be described as rights of belonging. The civil right to form a labor union and to decent wages for safe labor, for example, were rights of belonging, aiming for a more decent, fair, and democratically participatory workplace. Those rights contrasted in ways that parallel the contrast now between constitutional and statutory anti-discrimination norms with the bare and sterile right to individual liberty presupposed by rights to contract. Contract rights at best create freer individuals unbound by paternalistic states, empowered, at least in theory, to set terms and conditions of their own individual employment by virtue of their power to exit. The Family and Medical Leave Act directly aims to strengthen actual communities in the home and in the workplace by pooling the cost of early infant care or the care of sick family members, and the ACA, Affordable Care Act, also likewise strengthens ties of responsibility among those who share risks in insurance pools. Violence Against Women Act aims to protect physical security toward the end of enhancing the protection of women's mobility and safety in the communities of home and civil life. No Child Left Behind, etc., styled laws aim for stronger communities, both in schools and in neighborhoods, benefit from the floor of equality, that they establish, rather than leaving parents and their children to their own individualistically fashioned means and needs and desires. Some of these laws can be and have been fairly described as anti-discrimination laws, but they obviously cannot be simply described as anti-discrimination laws, and they might not be best described in that way. VAWA, Violence Against Women Act, for example, most directly targets violence against women, not discrimination against them. IDEA aims to educate, not eradicate invidious distinctions. And the Family and Medical Leave Act likewise directly aims to support parents rather than discrimination against women on the job. So all of these laws, whether or not they can be described as anti-discrimination norms, aim quite directly to strengthen civic, communal, or neighborly bonds. Third principle, civil rights distinctively aim to protect those individual fundamental capabilities that are facilitated by law and which, as per Paine, cannot be perfected or endorsed or enforced by individuals standing alone. The civil right is a positive right of access to the laws, the legal structures, legal forms, and legal entitlements that in turn protect or nurture fundamental capabilities that cannot be protected without societal and civil interaction, encouragement, or involvement. So, the Civil Rights Acts of both the 19th and 20th centuries empower individuals who would be otherwise barred by dint of private discrimination from various social institutions that depend upon civil society and its law for their very definition. Buying and selling property, contracting for and then occupying hotel rooms, eating in restaurants, working at jobs under the same terms as white coworkers. That's the 19th century laws. Likewise, the Affordable Care Act protects the human capabilities of health and longevity through pooling risk and thereby ensuring improved health, which is facilitated not by individual effort, but by an intricate and interpersonal jurisprudence that interweaves statute, contract, and property law. Gun safety laws and the Violence Against Women Act protect the individual capabilities of safety, intimacy, and mobility, in Sin and Nussbaum's language. But they do it by seeking to limit the isolating fears and inhibitions associated with excessive private violence. They do it through a set of laws and legal institutions rather than through arming everybody or engaging in exhortations toward individual empowerment. The Family and Medical Leave Act likewise protects individual capabilities both for work and family life, not through cheerleading heroically individualized parenting, exhorting everybody to lean in, but rather through mandated employer-provided assistance with the cost of childcare. The underlying individual capabilities in all of these cases require legal structures, law, and social institutions, not just unimpeded individual initiative. Without the Affordable Care Act, our ability to live a healthy life is frustrated by poverty that prevents the purchase of insurance. Without FMLA, our ability to care for dependents and remain employed, our ability to participate in family and work life is hampered by our inability to share the burden of caring for newborns. Without gun control laws, our ability to move freely through our neighborhoods is hampered by our fears for our own physical security. Without education laws, our ability to participate in high culture, as well as in an educated workforce and public sphere, is limited by ignorance and illiteracy. We can't do any of that on our own, basically, and per Paine, that's where and why civil rights enter the picture. Okay, finally, there are four. This one's really short. Civil rights are aspirational. They're not positivistic. They're not a listing of what the state has provided through law. There are rights that the state should protect, even if it does not. The civil rights to employment, education, safe intimacy, health, those are aspirational rights that we have, even if and even though they're only imperfectly secured by various statutes. Now let me contrast this conception of civil rights, Paine's understanding basically, with the conventional and truncated understanding of the civil right that I believe wrongly dominates our civil rights conversations. First, and as I've stressed, the Painean conception, unlike the traditional, centers rather than ignores the content of the underlying civil rights protected by the anti-discrimination norm, rights to contract, employment opportunities, education, and so on. Second, the Painean conception is aspirational, meaning it's rooted in natural as well as positive law. The civil rights we have are those we should have, not just the rights we've already won. Third, and as I'll elaborate in a moment, civil rights so understood are neither constitutional rights, nor in my view are they quasi-constitutional rights. Their recognition might be necessary to further particular constitutional guarantees, but their meaning and their reach and their implications are not defined or limited by those guarantees or the constitutional texts that provide them. They are determined by our nature, not by our law, constitutional or otherwise. Fourth, civil rights, so understood, are rights to state support, state law, and state institutions that are necessary to their enjoyment. Under the Painean view, as I've constructed it anyway, this positivity is a central feature of those rights definitionally, rather than an awkward and contingent feature that clumsily contrasts with the overwhelming negativity of the constitutional rights with which civil rights are often grouped under the traditional view. And then lastly, the barriers to the full development of our capabilities that relate to community participation and that require law for their perfection on the Painean conception do not end with discrimination, either public or private. Poverty, poor education, poor health care, and vulnerability to violence are also barriers. Laws that seek to counter those barriers, no less than laws that seek to counter discrimination on this understanding of the rights at the heart of civil rights, are core, not peripheral examples of civil rights acts. So collectively, civil rights laws all guarantee rights to which we are entitled by virtue of membership in society. Some, but not all, do so by providing rights to those rights against private or public discrimination. What they all do, though, is confer rights to participate in civic structures that are the products of law: public education, public markets, and insurance, secure and safe, unarmed communities protected by a trustworthy police force, structured and legally mandated postpartum support in the aftermath of a child's birth. Laws that do so, the alphabets do, such as FEMA, VAWA, ACCA, FLOSSA, NCLB, and IDEA, all the laws I've talked about, whether or not they aim at discriminatory public or private conduct, are also quintessentially civil rights laws. So let me now contrast constitutional rights with civil rights. The question that's emerged in scholarship over the last 10 years or so is this: are civil rights, both those protected by the Civil Rights Act and more generally, best understood as constitutional rights or as quasi-constitutional rights? A number of commentators over the last 10 years, including, I think most importantly, Bruce Ackerman in his Holmes lecture on this subject, have suggested or argued just that. However, once we include within the scope of civil rights the underlying rights those Civil Rights Acts protect, if that is, we examine civil rights in the Painean sense so as to include the rights protected against discrimination rather than just the anti-discrimination right itself, it's clear that civil rights contrast far more than they compare with constitutional rights, and particularly with the newly discovered constitutional rights that have been recognized or argued for or contemplated over the last 20 years or so. Painean civil rights and constitutional rights, so understood, are not only not co-constitutive of constitutional law, but they are increasingly on a collision course, and it might be wise not to obscure that fact. So let me draw out the contrast. Civil rights are rights to be included in a participatory public life. As noted above, Professor Zeitlow calls the anti-discrimination rights that those acts created rights of belonging, and I share that instinct. But I would say, I think more inclusively, that civil rights protected by anti-discrimination rights are rights to enter. They are rights to enter schoolhouses or workplaces or homes or marriages or neighborhoods or public spaces, hotels and restaurants, and so on. Understood as such, civil rights contrast, they don't compare, with a group of constitutional rights that cover much of the same lived geography and that have been sought or recognized or argued for over the last 30 years, which I've elsewhere called rights to exit. The still contested but increasingly recognized constitutional right to homeschool one's children, the constitutional right to die, the right to not buy health insurance, the Second Amendment right to own a gun and use it in self-defense, the ever-embattled constitutional right to procure an abortion, and most recently the right of religious schools to exemptions from anti-discrimination law for the hiring of their ministerial teachers, and the right, of course, of religious employers to exemptions from the Affordable Care Act to protect the sensitivities of conscience. The contrast between the civil right to enter and the constitutional right to exit can be drawn pretty sharply one by one. Thus, the civil right to a public education, in contrast to the constitutional right to withdraw one's kids from school and homeschool them, reflects values of shared sacrifice and common purpose, both in the ways in which it's funded and in the content of what is conveyed. The civil right to an education is a right to enter a public world of education, while the constitutional right is the right to exit that world. The constitutional right to homeschool is the right to exit it. The civil right to unpaid leave during a child's infancy, to take a second example, is aimed at permitting a parent to enter a familial and parental relation, rather than providing a constitutional right to exit such a relation through an abortion. It imposes a responsibility on the community as shareholders, customers, and co-employees for the shared burden of the costs of the care required to nurture newborns or sick family members, rather than giving an individual right to avoid those costs by aborting a fetus. Again, it's a right to enter a world of shared responsibility for parenting, while the constitutional right to an abortion is a right to exit both the biological relationship with the fetus and with other potential caregivers. The civil right to physical security implied by the Violence Against Women Act, as well as decent gun control laws, create a community of shared interest among community members who have laid down their arms, and a state's police force, rather than a distrust of either the competency or the desires of the police to provide that protection that's reflected in the Second Amendment's right to bear arms, as currently interpreted by the Supreme Court. The civil right is a right to enter a social compact and protection in exchange for forbearance, while the constitutional right is a right to exit that contract. The civil right to health care spreads the burden of sickness and illness over a community through this mechanism of shared risk, rather than giving to the individual a constitutional right to either self-insure, self-help, or commit suicide. The civil right to health care, in other words, is a right to enter a civil world of shared risk, cross-subsidizing insurance, and at the end of life, communal hospice care, while constitutional rights to die and to refuse insurance are rights to exit those worlds. And of course, the civil rights to non-discrimination, the rights of belonging, as Zieblo dubs them, protect rights to enter employment and education institutions, while the freedom of the church, now being pressed by scholars and to some extent by courts, protects the rights of churches and the schools and hospitals they sponsor to exit those laws through blanket exemptions in the case of churches themselves and various ministerial exceptions and conscience exemptions for the schools and the hospitals they sponsor. So in each of these examples, the civil right, unlike the constitutional one, not only envisions a community constituted by the civil right to enter, but rests on an assumption of trust and common purpose between the individual holder of the civil right and his or her co-citizens. Parents, teachers, neighbors, and taxpayers share the burden of educating children. Employers, co-workers, and customers of an enterprise as partners in the financing and support of new parents. A community of insured individuals and medical professionals share the burden and risks of sickness. And between neighborhoods and police, empowered to minimize violence and responsible and humane ways. So in other words, some of you read for this morning's class, I put forward the claim that these constitutional exit rights represent the first wave of an emerging new paradigm of constitutional individual rights. Unlike earlier First, 14th, and Fourth Amendment rights valorized during the first two-thirds of the last century, this new generation of constitutional rights, rights to homeschool, to own and use a gun in self-defense, to procure an abortion, to die, to refuse health insurance, and to exempt oneself from anti-discrimination law by referencing one's conscience. All of these are rights that facilitate not just the liberty of individuals within the confines of civic life, but a quite extreme form of exit from civic life and from the community and the state that structure it. They guarantee exit, that is, from some aspect of the social contract that defines civil society. The constitutional right to own a gun and to use it in self-defense is a right to not participate in, to exit, the traditional liberal social compact by which we disarm, relinquish our right to self-help, although not self-defense, in exchange for the sovereign's duty to protect us from private violence. It's a right to exit that part of the social contract constituted by the trade of one's right to self-help in exchange for the civil right to protection from violence. The constitutional right to die is a right to exit not just life itself and its biological ties, but also the social compact by which that life is protected against self-abnegation. It protects the most isolated, solitary, non-communitarian act an individual can possibly make against the paternalistic interventions of community, family, medicine, or state. The abortion right as well, which is older, but consistent with the newer rights, is a right to exit an unwanted relationship not only with the fetal life within, but also from community, family, or state that seeks to protect it on moralistic grounds. Both killing oneself and aborting fetal life do, after all, like killing an intruder in justified self-defense, sever earthly coils of some form. The right to homeschool one's children with no supervision from a school or school board that is recognized by some lower courts as well as by a number of school districts now in cash-strapped states is similarly a right to exit from this civic and shared project of intergenerational public education with its shared liberal norms of tolerance, pluralism, and light liberal feminism. The homeschooling parent seeks to exit that shared communal project of education as well as oftentimes its shared goal, which is a civic life informed by norms of tolerance, gender and racial equality, and individual but civic autonomy. The right to not buy health insurance, which was heartily insisted upon by Chief Justice Roberts as well as numerous commentators, is likewise a right to exit, this time from the shared social project of pooling health risks through the mandatory purchase of insurance. All of these newfound rights, the oldest being the abortion right, are echoes of the much older Lochner-era contract right, which within the context of employment confers an explicit right to exit at will the employment relation. In every one of these cases, the constitutional right found by the Supreme Court or ardently desired by advocates is not only not a civil right of belonging, quasi or otherwise, it's the antithesis of one. The constitutional right protects the individual's right to exit the very community that the civil right, at least on the Painean conception, protects and nurtures and seeks to promote. Civil rights and constitutional rights, then, are not mutually constitutive, they're on a collision course. So let me draw out one final contrast. Part of what is distinctive about exit rights, rights to homeschool, to kill oneself, to abort, to refuse to buy health insurance, to lethal self-help against violence, is their tragic hue. They protect a radical separation of the self from others, or at best an extreme alienation from the civic national community. The homeschooled child is homeschooled precisely in order to maintain or erect a strict separation from that community. The health insurance holdout wants nothing to do with an obligation to support co-citizens in this mutual web of obligation toward the shared goal of a healthier community. The gun owner risks his own death and that of his loved ones as the price he willingly pays for his rights of self-defense against hostile outsiders and an ineffectual or worse police force. The free contractor from the Lochner era deals with unhelpful co-contracting employees or employers through the right to exit at will. The suicidal individual and the woman obtaining an abortion are both dealing in death. In each case, the constitutional exit right separates the individual from some feared part of a biological as well as social community, from a physical relation with a fetus that may threaten a woman's life or well-being, an intruder that endangers a homeowner's life, a public school teacher whose very presence exudes liberal norms of forced ideological inclusion and equality, and most poignantly, of course, the suicidal individual from his own pained body. All of this recalls, if nothing else, classical definitions of tragedy. In the last act of a tragedy, the characters wind up dead on the stage, with the community or the state from which they came torn asunder. In constitutional tragedies, those dead individuals, as well as the people who killed them, are shrouded in rights. Painting and civil rights, by contrast, are comedic rather than tragic. The last act of a classical or Shakespearean comedy typically culminates in a community ritual, such as a wedding celebration or the birth of a child, reaffirming the value of a shared communal life, both for the individuals involved but also for the larger society. Our civil rights are comedic in precisely the same way. If Title VII of the Civil Rights Act is working properly, the last scene of the last act of that legal drama is a workplace that's actually integrated, not as a society of atomistic individuals who may have rights against irrational state classifications. If Title IX is functioning properly, then in the last act, universities and colleges are healthier communities. Women are actually playing on those sports teams. African Americans are actually participating in the classrooms. When the Family and Medical Leave Act is working properly, actual workers tend to dependence in their real life families, creating stronger communities in homes and workplaces both. The parent nurtures the newborn child, the adult child cares for the parent, and both do so without fear of losing their place in the workforce. When civil rights to education are secured, the classroom is public in all senses of the word, publicly funded, publicly supported, open to all comers, and serving the public that funds it. It educates for citizenship and fulfilling lives. When labor rights are enjoyed, workplaces are healthier, better places, and more participatory. With the civil right to marry secured, the couple weds in a ritual of communal reaffirmation toward the end of a communally recognized shared life. With the civil right to gun safety and gun control, the neighborhood is safe, the individual and her community are supported and healthy. In the last act of comedy, not just individuals, but the communities in which they live are on stage, celebrating these civil rights that unite and support them. Okay, so it's important to note, nothing Dionysian or even romantic about any of that utopian vision. These rituals are made possible by law, and lots of it, not by an inherently sociable nature. So all of these rituals, the marriage, the opening of a school, the integration of a workplace, the care of a newborn, policing of a neighborhood, are not just dependent upon, they are fully constituted by law and legalism. The workplace is a product of contract property and labor law. The parent's nurturance of a newborn without fearing loss of employment is a product of an act of Congress. The safe neighborhood is the end result of a social compact that exchanges at its core the natural right of self-help with the mutual obligations of a communally funded and manned police force. The healthy individual owes her health to the pooling of risk, itself facilitated by a set of tax and spending acts of Congress. And civil marriage, as commentators on all sides of the debate surrounding its expansion have noted, is a product of law and legalism, not of faith traditions. There's nothing particularly romantic, in other words, and certainly nothing anarchic about any of these rights. Healthcare is not something we enjoy by nature's bounty. It's something we enjoy if we've structured our community and its law in a way that's conducive to pooled risk. Education is not something that Emil will pick up willy-nilly if we would just leave him to his own devices. It's a highly structured product of law, bureaucracy, deliberation, compromise, and pedagogy. Safe neighborhoods are not the spontaneous flowing of a natural Homo sapien community in Walden Pond. They're the deliberate outcome of a self-motivated contract through which we exchange natural rights and self-help for a web of communal protection. Our own health is not something we enjoy in a state of nature, quite the contrary. Lives would be notoriously nasty and short, even without the brutishness. But it's something that's produced through effective law that facilitates the production and the distribution of effective medicine and medical care. An integrated workforce, access to fair labor, is not the natural product of a primitive instinct to bargain or unstructured spontaneous contracts without need of public enforcement. It's the product of legalistic constraints on those instincts. Civil rights speak to our capabilities, our respect for community, our recognition of how law is in service to those communal instincts. They speak to law's virtue and law's necessity, not to law's mendacity or its irrelevance. They are, in short, rights to law. They're not rights to be free of it. We would not enjoy the goods they promise or the capabilities they protect, health, education, welfare, safe neighborhoods, decent work, family, and marriage, without law's presence. Our civil rights do a lot of things, but one important thing they do is embody our respect for the ways that law constructs and constitutes and provides architecture for our embattled and bruised commitment to the common good. Can I take 5 minutes for my conclusion? Okay, so by way of conclusion, let me look again at the killing of Trayvon Martin, the trial of George Zimmerman for that death, and its aftermath. So the failure to find Zimmerman guilty of second-degree murder may or may not be attributable in part or whole to either intentional or unintentional racism on the part of the jury, the judge, the community, the prosecutors, the expert witnesses, the police force, and the defense team. If it was attributable to such discriminatory animus, then there may well have been violation of not only the anti-discrimination norm in the abstract, but also of Martin's civil rights, both as I've defined them here and as they're traditionally defined, primarily to security and protection. But whether or not that's the case, there's another violation of Martin's civil rights revealed by that tragedy, but which is not fundamentally a function of racism, although it is certainly exacerbated by racism. Stand your ground laws, as well as newly broadened self-defense laws that expand the scope of permissible violence and altercations, basically expand the scope of justified lethal force to include all scenarios in which a combatant is in fear of his life, regardless of who or what triggered the fight that put him there. So you can, that is, stalk somebody as long as your stalking is itself legal, pick a fight with him, find yourself losing the fight, consequently you're in fear for your own life, and then you fire a gun with the intent and the hope to kill, and it's all in justified self-defense. That's what Zimmerman did. Martin's mistake was to fight his stalker effectively. Zimmerman's justified lethal violence, because it was lawful self-defense, then, was not criminal. That which is not criminal is legal. So when we expand these self-defense laws with stand your ground laws and simultaneously protect rights to carry weapons, we have in effect changed the terms of our civil or social compact. Some measure of public civil violence is now fully permitted that was fully criminal a very short time ago. When we embrace broad defenses that shrink the sphere of the criminality of lethal violence, we not only expand the scope of permissible individual self-help in altercations, but we also shrink the sphere of the pacific civility that is expected of us in our public as well as our private spaces. So if a combatant is permitted to carry a gun, start a fight, stand his ground, regardless of what he did to trigger the assault, virtually every fist fight, regardless of how it began, becomes potentially a justified homicide. The sphere of peaceful coexistence of community itself is gravely reduced. It seems to me that on Paine's understanding, this entire body of newly made law, with state statutory and U.S. constitutional underpinnings both, far more clearly than the jury verdict acquitting his killer, is a massive violation of Trayvon Martin's civil rights. By virtue of its enactment, Trayvon's civil right to the enjoyment of his physical security, his equally civil right to the state's protection of his physical security, that's what was not protected that night on his walk back from the store to his dad's apartment. The core civil right Paine urged is the right to the state's protection of one's physical security. That protection to which we have a right is and must be provided by the state. It's the paradigmatic right that we cannot perfect on our own. The authors of the 1870s Ku Klux Klan Act realized this. The authors of the Equal Protection Clause of the 14th Amendment recognized this. The authors of the late 20th century's Violence Against Women Act recognized this. The authors of our various criminal codes recognize this. Yet somehow, we've lost track of the civil rights underpinning of our right to be protected by the state against private violence. Instead, we keep shrinking the scope of the right to be protected while constitutionalizing various rights to kill each other. So, I'm not urging a massive enlargement of our overly punitive criminal justice system, but it hardly follows from the sad fact that our criminal justice system is unjust, that what we should therefore do is return the streets to the armed. The result of the abandonment of the civil right to protection against violence and the civil duty of the state to provide it, whether through the defunding of police forces or the expanding of these self-defense principles, is and will continue to be increasing carnage in homes and schools and on public streets all. That carnage, no less than discriminatory law enforcement, is the central civil rights issue of the age. It should not need to rear its head only in the aftermath of spectacularly tragic public killings of innocents. There's now no question but that this breach of our civil rights, the failure of the state to protect us all against private violence, impacts blacks more than whites, and black youth far more than white youth. It is young black men and boys, more than white men, who are targeted not only by ordinary crime, but also by vigilante neighborhood watch groups staffed by white men carrying guns, and whose death-dealing acts of killing are then tallied as justifiable homicides. The civil right, then, of which young black men are deprived is not only the right to be free of discriminatory policing and profiling and discriminatory sentencing policies — I'm not denying that any of that is a problem — but it's also the civil right to live out their lives without fear of intimate and neighborly, and as it turns out, fully legal violence every time they walk from their homes to their neighborhood stores. Both they and the rest of us are deprived of that right by virtue of neutral-sounding expansions of our self-defense laws, stand-your-ground laws, open carry laws, constitutionally grounded gun rights, all of which collectively have an horrifically adverse impact on minority communities. But the existence of the civil right these laws offend does not depend on that showing of an adverse impact. The thoroughly positive right to the thoroughly positive state-provided protection against thoroughly privatized violence is maybe the quintessential civil right. It's a right that can only be realized through the enactment of positive law and its fair enforcement. It's a civil right to the protection of the state against private violence occasioned upon him by George Zimmerman, as accomplished here through the state of Florida's quite intentional shrinkage of their criminal law of homicide, which was denied Trayvon Martin. A civil right, again, is a civil right to law, in this case to laws that criminalize private violence. That civil right cannot be realized through negative rights to be free of law, nor can it be realized by rights to be free of state or private discrimination. It cannot even be seen, in fact, as the civil right, so long as we remain besotted by our negative constitutional rights to be free of the state, which are then leavened only by an insistence that the state not irrationally discriminate between us. Neither are the two dominant understanding of rights that circulate in contemporary legal culture, our understanding of our beloved negative constitutional rights that shrink the role of the state in our lives, or our limited understanding of our equally cherished civil rights to non-discrimination. No matter how seriously we regard those rights, will be of any help on this one. All of the constitutional rights and anti-discrimination rights in the world would not have helped Trayvon Martin against George Zimmerman's fully legal and lethal force. For that, we need to regenerate interest in and commitment to the rights to civil society, including Trayvon's civil rights to physical security and mobility, envisioned by early and largely forgotten architects of our classical civil rights tradition. Thank you. Am I calling on people, or are you, Sona? Or are we waiting?
Okay, they need to have the mic.
Oh, okay. I just see people's hands up.
I'm trying to go for student first, so.
That's age discrimination.
Two. All right.
I'll go. That was really fast. But I'm not a lawyer. I am a human. And it seemed to me that you make this interesting comparison between the entry rights, the civil rights, and the exit rights. It seems to me like the entry rights are a good deal for me if the society that I'm entering, cooperating with, is just.
Correct.
And if it's unjust, then these exit rights become a lot more appealing to
That's
me.
right.
That I want to isolate myself from these things I feel that are negative
right.
or.
That's-
So they're both important, because any time society that you believe is just can become unjust,
Correct.
as we saw in World War II,
Yeah.
and both seem equally important to me. I'm not sure that they seem equally important to you.
Right. So I have a rather more bleak view of things. It's generally true. So, yeah, exit rights become more appealing as the state from which you're secured a right to exit becomes either unjust or what I would call more provocatively a failed state, okay? And what's interesting about the exit rights, what I'm calling the exit rights that we've been recognizing over the last 10 or 15 years or so, is the degree to which they're premised on the assumption of a failed state even more than an unjust state. So the right to guns, for example, if you read the briefs, the Supreme Court opinion, all of that, the premise is not so much an unjust state. It's not fear of the totalitarian Leviathan. It's the state that doesn't respond to your 911 calls. And by the time the case gets decided by the Supreme Court, it's the groups that are advocating for it, for the Second Amendment right, are no longer talking about, the UN coming in with their scary black helicopters and destroying American sovereignty or anything like that. They're talking about police forces that don't respond to their needs for protection against intruders in their homes. And so, and the state's response to that is, look, we're not responding because we're mean people. We don't have the resources. And so, that has all of the ingredients of just a failed state, a state that doesn't have enough resources to do the basic core functions, okay? Protect people against violence, educate children. The same thing's happening on the schooling front. The public schools are now increasingly coming down in these cases trying to assert a right to homeschool on the side of the parents advocating the right? Why? Because they say, we don't have the money to educate all of these special needs and precocious kids anyway, so we're fine. It's fine with the idea of the parents having this right to homeschool. Go to it. They want to have the power, right, to insist upon the parents' right to pull the kids out. And so, and that again, that's not because they don't have an interest in educating people. These are all educators. It's because they don't have the resources. And so, so it seems to me, yeah, you're certainly right about the relative value or the disutility of these rights depending upon the quality of the state. But what I find alarming about the exit right phenomena is that the claim for them is increasingly not that the state's doing something that I don't like, that it's unjust, even that the democratic process is broken down, but rather that it's not doing some core function. It's not, and policing and educating are two core functions. And so when you start having a right to pull out of and to privatize what have for a long time been understood as core functions of the state, it seems to me that's really problematic. And so that sort of tilts it, in my view. But I certainly take your point.
I also was very taken with this idea about the constitutional rights and the civil rights as being potentially on a collision course with one another, and I found that very interesting and provocative. And I definitely see your point, and am very much in agreement, particularly in the Trayvon Martin illustration of that. I wonder, though, whether it's in all cases necessarily an inherent disconnect between the two, or whether it's more about a tendency that we've seen over the past, I don't know how long, but to interpret or to approach constitutional rights in absolutist terms, or in sort of a myopic type of interpretation, as opposed to seeing constitutional rights within the larger framework of the Constitution, the larger sets of goals that the Constitution is trying to accomplish. So I wonder the extent to which you see it as being an inherent conflict, or whether more of just an interpretive conflict.
I think it's an interpretive conflict, but with limits to that sunny, optimistic view. That, look, Section 5 of the 14th Amendment, to my mind, clearly empowers Congress to pass laws, right, that will do things that the states have failed to do in terms of protecting people in all these various ways. And so it looks like there's a constitutional authority for this, and it looks like there's a constitutional kind of endorsement of this. But it hasn't been interpreted that way for over 100 years. And so at some point, interpretation becomes sort of constitutional fiat. That's the fear. But sure, when VAWA was passed, the Violence Against Women Act, a number of us legal academics filed an amicus brief arguing that this should be understood as a Section 1, Section 5, 14th Amendment case, not a Commerce Clause case. But, it didn't go anywhere. It didn't go anywhere. And so Section 5 has been almost read out of the amendment. So I don't know. Look, one thing that Bruce Ackerman is trying to do by arguing that all civil rights are quasi-constitutional rights, right, is to change the content of constitutional rights so it's at least a mixed bag of this stuff. I just think it's not very realistic, and that it's not only that, it's also that constitutional rights, including in Ackerman's formulation, are absolutely court-generated. and civil rights, for the most part, have been the product of democratic deliberation in Congress. And so if you solve this problem, if you sort of resolve this tension by trying to collapse everything into the constitutional sphere, in a sense, you're giving up on democracy. I mean, in a limited sense, but nevertheless, you're sort of delegating to the courts the jobs of self-government that really should be pursued democratically. And so that's one reason I want to just put civil rights on its own bottom, so to speak.
In the fall, we had a lecture by a professor from Harvard, that whose name I forget, but he was a public ethicist, and he was dealing with one specific problem: how to provide health care for illegal migrants. And he was unconvinced that that was a human right, because he had gone through various listings, like I think the UN Declaration of Human Rights, and didn't find it there. And his view was that something like that came out of participation in a community. That, you know, unlike, he contrasted tourists who wouldn't have the opportunity for affordable health care to somebody who had lived in the United States, who had had jobs but were still an illegal alien. And it seemed to me that you're getting there in a different way, that you're getting there through laws and citizenship. How would you deal with the problem of, you know, health care for illegal migrants?
Right. Okay, so I think that the example illustrates the limits of civil rights. Civil rights are not coterminous with human rights, and on anybody's conception. And so I don't know what the argument was from the other speaker, but I don't know. I think that one could expand, at least my understanding of civil rights, to include a civil right to health care for folks who have been here for some period of time. But the newly arrived, it's going to be a lot harder because of this sort of underlying layer of, because of this understanding that the civil right is based on, social compact, basically, where you're giving. So I think that the first assumption that the guy made, that if there is such a right, it's going to have to come from a human rights tradition, is probably right. And so the question is, what's the... Yeah, I know, and so therefore it doesn't exist. What I'm saying is, I think that it's correct to say that if it exists, it comes from, it's properly understood as a human right. It has to do with the obligation of the community to people that are here, whether or not they're documented or not, to provide health care. So it rests on an understanding of health as a human right, I think, instead of an understanding of health as a civil right. But it's a good question. I have to think about it. I think it's a serious limit of both the civil rights tradition and the constitutional rights tradition and the legal rights traditions that they all are premised on citizenship. I mean, that seems to me a sort of flaw that can't survive a robust human rights movement. If you have a robust understanding of human rights, this concept of citizenship has to be suspect. That's another way to put it. I don't know who's calling on people. If you want to make these choices, that's good.
I am wedded to the old constitutional law interpretation of rights. Consequently, I wonder if you can't get to where you've gotten by expanding some notions that were being developed back in the 60s, like Frank Michelman's idea of a right to minimum protection,
Right.
which didn't get much follow-up.
No, it didn't.
And also, nobody pays much attention to the Rawls theory of justice anymore. But in the Rawls theory of justice, we're talking about creating a new social contract.
That's right.
which would then begin to embrace a framework
Right.
that you are articulating.
That's
The
correct.
problem I have as an old-time civil rights lawyer is that my understanding of civil rights is something that a court is going to enforce. That all rights is something that courts are enforce, or that Congress will make a law about, or a state will make a law about, which is ultimately enforceable. Because it's not enforceable, it's not a right. It's an aspiration, it's a hope, it's an expectation. But we don't live in the kind of society that I would love to live in with you. It's not.
Not just me.
No, well, and most people in this room. A society that I would say is more in the tradition of a social democracy than the history in the United States. When I was listening to your lecture, which is extraordinarily complex and brilliant, I was wondering, you know, what if Bradley hadn't written the civil rights cases in the way he did? If the state's action limitation hadn't been placed on it?
Right.
If those things hadn't happened?
Those things hadn't happened, right.
If
Right.
the Civil Rights Act were based on the 14th and 13th Amendment rather
Right.
than on the Commerce Clause,
Right.
your arguments would be largely undercut, wouldn't they?
I don't know about undercut, but they would not be so driven by felt necessity, let's put it that way. And so, but there are a few things that you said. I think that the idea of civil rights as judicial products, I just don't think that's right. First of all, the idea that what's been described here is just a utopian social democracy. Every law I discussed is an actual law, with the exception of some of the rights to marry stuff. And so these are actual laws. They're not just my dream of the way I want to live. But I think it's important that for the most part they came from legislation rather than from the courts. And so yeah, they're only real if they're enforced by courts. But to be real, they also have to be produced. And these things are produced democratically. And I think that's a very big difference from what the courts are sometimes willing to do and most often not willing to do. They also, I think, have had more staying power. So if you look at just the track record of Brown and its legacy in the courts and the Civil Rights Act of '64, just on the anti-discrimination norm, the '64 Civil Rights Act has been much more efficacious. I mean, it is fulfilled its promise in a way that just way outstrips Brown. We're nowhere near actual integrated schools. We are somewhat nearer to integrated workplaces. I'm not saying Brown shouldn't have happened.
No, I'm saying the Civil Rights Act.
Oh, yeah. No, that could be. We'll never know. It's a counterfactual, but most likely, that's the history that we've got anyway. And yeah, sure, the court was part of the prodding, to Johnson and to the Congress to do this. They were also moved, though, by the fact that there were large segments of the American public by '64 that were for it. And so there were democratic influences at work as well as judicial influences at work. I forget the first part of your challenge. Yeah, so if we don't have the state action requirement, that's what I was. Yes, absolutely. And look, I've made that argument for years, okay? The state action requirement is just a big perversion. It's not what was intended by those Reconstruction amendments. It's just really obvious. It's even obvious if you just read the text of the thing. And so, that's a tragedy. It's an unfortunate fact of our history, but this is like the question of how necessary is the constitutional tradition. Keep putting all your eggs in that constitutional basket. At some point, the combined force of years of interpretation, a very narrow interpretation of those constitutional aspirations comes back to bite. I think it's coming back to bite us now. And colorblind cases, right to bear arms, all of that. There was this man's hand.
Thank you. Again, a wonderful speech and so provocative and stimulating. I wonder if you would be willing to qualify when you speak of Constitution and constitutional rights to limit yourself to the federal Constitution.
Oh, yes, absolutely.
Because the communitarian rights that you describe
Right.
do exist in state
Constitutions, that's correct.
And this conflict that you describe of
Yeah.
rights to enter and exit is certainly being consciously engineered and is aimed very largely at undoing the positive rights that exist at the state level.
Correct.
In every state, there's a right to education, and
Correct.
the rights to the protection of the law that you're
Right.
talking about is a
Right.
positive right. Those are state rights.
State constitutional rights, you mean?
Yeah.
Yeah, and state constitutional rights as well as state statutory rights. No, that's absolutely correct. My comments are directed at federal constitutional law. I should have said that. So, yeah, state constitutional rights are extremely important. They're also, state constitutions are a bit more democratic, too. I mean, they're more subject to votes, popular votes, as well as legislative change.
And I guess I would offer just a comment that the negative federal rights are being used consciously to undo the positive state rights.
I think that's correct.
Yeah. And I would ask you to consider whether your right to enter doesn't apply to persons rather than citizens. Citizenship
That
is
is
no
like the
longer
first
the
issue.
locus of
Yeah.
civil rights. It's
Yeah.
personhood that's protected in our society.
Yeah,
So
I
it's-
mean, okay, so I didn't mean citizenship so much. What Paine was saying that I do want to endorse is that there are natural rights, they attach by virtue of humanity, but there are also rights that require the law for their protection, for their perfection, unlike the negative rights of conscience and speech and all of that stuff, which require the state to just stay out. Civil rights, seems to me, it's been true in our history, are the rights that actually require positive law, so they're rights to positive law. Another way to put it is they're positive rights. I meant that more than the citizenship stuff. But yeah, as I said, I think the shared sort of tragic flaw of U.S. constitutional rights, civil rights, legal rights discourse has been this embrace of citizenship. So yeah, I take the point. I think if I said that, I'm going to change that.
I was wondering if you could expand a little bit on the idea of the right to die as an exit right. I guess maybe it's because I'm so ingrained with the idea of the right to privacy and the right to choice. And it came up a little bit earlier in class when we were talking about abortion as a choice issue. I was wondering if you talk a little bit more about that and how that plays into the difference between a healthy state versus a failed state, the idea of, well, shouldn't we still have some of these choices and protections in in a better situation?
Okay, so first of all, I'm not uniformly opposed to all these exit rights, including the right to die and the right to abortion, both. But I think that you need to, I think that one should be attuned to the failures of community that some of those rights symbolize, but also sort of feed on. And the right to die, right, does give us an out in the task of providing palliative care. And so that is something that people should worry about. I mean, people who advocate for the right to die do worry about this, and they have all sorts of ways to try to limit it so that this doesn't happen, so it doesn't just become a slippery slope to okay, you've got that right, so we don't have any obligation to help you out here at the end of life. So as I said in class earlier, I think of some of these rights as canaries in the mine. It's not that they're bad things, but that they can, they often symbolize, and sometimes they rhetorically promote, a world in which communal obligations to prevent whatever it is that gave rise to the need for that right from happening. So I mean, I think of the right to die and the right to abortion as both fitting that structure. The justification, I think I talked about this earlier this morning, but the justifications of the right to abortion have shifted away from choice and from a woman's control over her own body to instead, you got to have a right to abortion because we don't have decent child care policies in this country. And that's true, but it's also something we should all be a little bit alarmed about. Right?
So I guess my question is there a constitutional basis for striking down some of the rights that you deem problematic? I don't just mean if the petitioner claims that I have this right and that should be recognized right, but whereas the right is something that's already in operation at a lower level and the court has to, like someone can say that the existence of this right or the granting of this right deprives other people of their rights. So like rather than like in a law specifically, or like, this right has that consequence.
Okay, I'm not sure I get the question, but here's one thought that it triggered. Some of the ways in which I think these federal constitutional rights stand as a real threat to a robust civil rights enforcement comes in part from the fact that the civil right that's a product of congressional action is a legal right. It's an ordinary old legal right, okay? So like in Hosanna Tabor, which is a recent case in which the court granted an exemption to church-sponsored schools from the Civil Rights Acts, right? The majority opinion in that case provides about 20 pages worth of textual explication of the history of the church, going all the way back to like the 13th century, as being a separate sovereign from the state, in pretty glowing terms. Provides one sentence of history of the Civil Rights Act. So you talk about an unfair fight, right? Okay, so you have a right, right? I mean, a constitutional right, heavy-duty constitutional right, free exercise, et cetera, on one side. And what do you have on the other side? I think his account of the Civil Rights Act was, this is a law that gives some rights to some employees. So it's a given as soon as you get to that part of the opinion who's going to win this case. In other words, so constitutional rights act as trumps. And so if the fight is between a constitutional right on the one hand and a legal entitlement that you have by virtue of something that some Congress passed sometime, 50 years ago, the constitutional right's going to out. And so part of what I want to see is just an elevation of the civil rights to, rhetorically, to this a sort of equal stature. I don't know if that addressed your question, but what happens in some of these cases in which a constitutional right is pitted against a civil right is that the civil right is defined as just a sort of public policy objective. So gun control, for example, that's just a public policy, and states are all over the place on it. But the Second Amendment is is the right that that's valorized. If that didn't come anywhere close, just ask me afterwards.
But we're seeing that
So,
the civil rights that you speak, you speak of them in conjunction, sort of coming out of the democratic process. That democratic process is highly imperfect.
No kidding,
With some
yeah.
pretty crazy laws
Yeah.
that I would argue, it
Right.
might be preferable to have these exit rights
Yeah.
trump.
Yeah,
the
yeah,
ones
yeah,
that
yeah,
come
yeah,
from the-
yeah.
from the
Yeah, no,
past.
I get where you're coming from, believe me. And so many of the exit rights that I'm talking about, which sound like they're politically coming from sort of conservative organizers, have their origins in liberal victories, right? I mean, the right to homeschool was started by John Holt in the 60s for sort of, anarchic parents who wanted to do their own thing because they didn't like the militarism of the public schools. I don't know, there's multiple examples along those lines. Homeschooling also has its legal origin, I think, in Yoder v. Wisconsin, which was widely lauded as a great liberal triumph, the case involving the Amish parents. This came up, I'm getting all of these, it was either in class this morning or breakfast with the students or lunch with the faculty, in one of these forums, right? The point was made, similar to your first point, that the relative value of these kinds of rights depends upon the quality of the state that you're seeking to enter, that you're seeking to exit. And another way to think of it, the sort of quintessential exit right phenomenon might have been the commune movement in the 60s, right? Where that was certainly lumped politically in crass terms as on the sort of liberal side of the spectrum. But at any rate, yeah, so depending on how bad things get, right, we might want to take some of these exit rights a little bit more seriously, yeah. But I wouldn't give up right now on our poor, damaged first branch.
so I was wondering, through what ways can we reconcile this conflict between constitutional and civil rights? Is it through enacting more laws that foster the goal of civil rights, or somehow changing the Constitution, even though it might be very hard to include these goals of the civil rights, or enlarging the role of the state in many social
Well,
democratic states?
Yeah,
say?
no, I get it. So the most direct route to reducing some of this conflict, reducing some of this tension, is by arguing for and then eventually persuading the court to take Section 5 and Section 1 of the 14th Amendment a little bit more seriously. And so that the grounding of the civil rights acts that come from Congress is not regarded as depending upon the Commerce Clause, but is actually understood as in line with constitutional aspirations for equality and liberty. I mean, that's the sort of legalist hope or lawyer's dream, that's what you do. You keep litigating until you get a court to say, yeah, these civil, and this is sort of what Bruce Ackerman is doing. You want the court to acknowledge that civil rights are consistent with the constitutional tradition. The worry is that they're not. The court's not going to do that, and it's going to be a long time, not in our lifetimes, till you get an actual sort of change of personnel on the court that would even hear or understand such an argument. Breyer came close, actually, in the Bawa argument to getting the point, but, it didn't go anywhere. And so, but I think you do all of these things. I mean, my own sense is that for anybody troubled by doesn't include you, by the proliferation of these exit rights and the fact that they seem to be multiplying, like once you're attuned to the structure of them, you see them all over the place. If you're troubled by that, it seems to me the solution is a reinvigorated political community and not a bunch of lawsuits. Because that's what exit rights are premised on, this failure of democracy. And so fix your democracy, right? I mean, get Congress to sort of be a functioning body again. But how you do that, I don't know. But it does seem to me that the proliferation of exit rights over the last 10 years is in part showing that.
Elect Democrats.
Elect somebody who does their job, right? Rather than people who try to make it impossible to do their job.
Well, let's end it there and thank